governor does not have the power to transfer the clerk? Is it the fact that we have a situation in contravention of Section 120 of the Constitution where monies were spent without a budget? I mean, what kind of political solution do you want to give to legal issues?
But wasn't that the same constitutional situation that led to some of those agreements not being implemented? I mean, we're looking at the Constitution now.
Yeah.
In those agreements at the time, there were some of them that negate the provisions of the Nigerian Constitution. Weren't they?
I have held this view by which I stand, and I said that I've taken a look at that presidential intervention. There is no clause in that presidential intervention that breaches the provisions of the Constitution. I have said that, and I stand by what I've said,
including a representation of the budget.
Yes, but if for you to say you don't want to represent the budget, is that you're making an argument that there is a valid budget. But there have been consistent lower and superior court of record that have said this budget passed by Edison Ehi has been nullified and voided. So the situation we have in Rivers State now has even moved beyond whether we have a budget or not, because at the moment there is no budget. And let me also tell you the important thing. Like I just said before, by virtue of Section 120 of the Constitution, you cannot spend from the Consolidated Revenue Fund of a state without an approved budget. No matter how beautiful and plausible your intentions are, the Constitution says that there must be a bill passed by the House of Assembly to authorize you to spend. But that's not the situation we have in Rivers State. So I am saying that the issues we have in Rivers State have moved beyond political issues. They are now purely legal issues, and courts have made pronouncement on these issues. And so the call by PANDEF for political resolution may not work at this point in time. Because what PANDEF should now be doing is to call the respective parties to now begin to obey judgments of court. That's the most important thing that PANDEF should call. Rather than say, let us still begin to meander, through a political resolution. Court judgments have been reached, delivered. The call by PANDEF at this moment should now be party A, B, C, and D obey the judgment of court. For me, that's what is important.
There's several responses came. You mentioned Martin Amewule, which will bring me to the visit of the national lawmakers and some of the other things that you've touched about, that constitutional issues that has also been cited by the government of Rivers State as to why it has been difficult to recognize them or even present the budget to them. And that would be the question of the affection, which has been the elephant in the room for a very long time. Constitutionally, what is the provisions regarding that situation?
First of all, if you take a look at Section 109, Sub 1G, which has been the bone of contention, it's to the point that when a member of the House of Assembly defects from a political party that sponsored him to another political party, he loses his seat. The challenge we have is that whether that is automatic. For you to make an argument that they have left their seat, for the courts to declare that their seats have become vacant, the court must make a finding that there was actually a defection.
Okay.
I'm coming. You're making an argument that somebody has left his seat, has defected. The person is saying, I have not defected. You see, the burden is on the person who alleges to prove. If you're unable for the court to make a finding that members of the House of Assembly have lost their seat, the court must first of all make a finding that indeed they defected. So, but you see, Section 109 must be read in context, which is what I've always said. That Section 109 has subsection 1, subsection 2, and subsection 3. If you take a look at subsection 2, it says that it is only the Speaker that can declare the seat of a member of the House of Assembly vacant. And I'll give you a historical antecedent of Section 109.
But before you get there, what you just cited now and what you said with the Constitution, it doesn't it then bring us to this? I mean, we all saw the videos on social media. We saw the letters that were written to this Martin Amewule at the time he was Speaker in the House before all of this imbroglio. And he read those letters and accepted those individuals who had defected on the floor of the House. Doesn't that state that, well, as in his capacity as Speaker, he had accepted that, okay, they've defected and moved on to another political party? Because that was exactly what happened and everybody saw that.
Can I tell you something?
Okay.
No matter whatever happens here now, if you allege that such a thing has happened, you have the courts to ventilate your grievances. The courts are established by virtue of Section 6 of the Constitution to allow parties ventilate their grievances. If you say, like people have always said, that they have defected, you have a court. What stops you going to the court to ventilate your grievance. Show all of this to the court. But let me also tell you one important thing, that anybody who is still talking about the issue of defection obviously has not read the judgment of the Court of Appeal delivered on the 13th of December 2024, where the Court of Appeal made a finding that there was no such defection, and said that Right Honorable Martin Samehule and other members of the House of Assembly are still members of the House of Assembly and authorized by the Constitution to carry on legislative business in Rivers State. That judgment is the judgment of the Court of Appeal delivered on the 13th of December 2024. Why are we still talking about defection?
Right. So prior to that time, wasn't there a judgment that had already ascertained their situation in the House as not being members of the House?
None. There is no judgment, whether from the lower court, from the Court of Appeal or the Supreme Court, that says that Right Honorable Martin Samehule is not a speaker, or the other members are not the members of the House of Assembly. I mean, if you take a look at the trajectory of cases, you have the one from the Rivers State High Court, you have the one from the Federal High Court, some of them dismissed at the trial court, dismissed at the Court of Appeal. But I'm telling you now that on the 13th of December 2024, the Court of Appeal made a finding that such a thing does not exist. So when you still see people arguing that, oh, people defected, it shows you one thing. If you're unable to prove your case, the court is not a Father Christmas. And in civil or in criminal matters, you must prove it on the balance of probability.
But if this is the case, what you're saying, how come we still have the matter of their defection still before the court and no judgment yet?
Let me tell you what has happened in all of this. We have the judgment of Honorable Justice Omotosho. The judgment of Honorable Justice Omotosho was appealed to the Court of Appeal. And if you take a look at one of the grounds that the governor also raised at the Court of Appeal, it was the fact that they have defected. The Court of Appeal didn't find that and said they had not defected. Then you have the judgment of the Court of Appeal from the judgment of Honorable Justice Wali. It didn't also say that they have defected. It still concurred that they are still members of the House of Assembly. Then you have the judgment of the Court of Appeal, which dealt with that of the allocation, which also made a finding that they have not defected and they are still members of the House of Assembly. Why are we still talking about
the argument then is whether or not the Martin Amewule at the time informed the court of the defection, because remember there was an affidavit that was sworn to as them swearing to be members of the APC. Now the question is, many argue that when they went before these courts, did they let the court know that they had already done something like this that indicates that they've left the PDP, the APC, or allowed the court to give a judgment blinded?
You win a case on the strength of your own case. I go to a court, I'm bound to do my own matters according to the fact that I present before the court. And let me
so you're saying it is okay if you are able to bend the facts,
hold on.
Just so you get what you want from the court.
Let me give you a very important issue so that you appreciate all that is happening. You are the one saying people have defected. You are the one laying credence to all of this evidence. You had the opportunity of presenting this.
No, people are not saying. People saw.
I agree.
And then that's what led to them say.
Yeah, whatever you saw, to you are facts. The court does not scavenge for facts. Parties bring facts before the court. Why is that important? You would realize on the 12th of December 2023, when the governor presented that budget before Edison here. That was on the 12th. On the 15th of December 2023, do you know what happened? Right Honorable Martin Samehule filed a motion before the court, asking the court to nullify that budget because it was not passed by the properly constituted House of Assembly. You who is saying that they defected on a date prior to when the court gave judgment, what did you do to bring that to the notice of a court? I mean, people are saying they have not defected. You go to court, you don't present evidence to show that they have defected. Then you come to the public, you flow with the propaganda saying you will not accept them because they have defected. Anytime you go to court, why don't you argue that before the court to show that they have defected? Obviously, because you know that the evidence that you have may not warrant the court to say that they have defected, obviously.
All right, we have a commercial coming, but then I'd like you to put out something from a statement from the Commissioner for Information. Okay. Says, clear beyond any shred of doubt that as of 29th November 2023, when suit number FHC-ABJCS 1613-2023 Rivers State House of Assembly versus the National Assembly of the Federal Republic of Nigeria was initiated before the Federal High Court, presided over by Justice Omotosho, Martin Amewule and his group had mandatorily become former members of the State House of Assembly. It's kind of, I'll go through it, but we don't have a lot of time. Let's just take this commercial, and when we come back, we'll look at that. Stay with us. The conversation continues.
Nigeria Info. right back after this.
Admissions announcement from Hezekiah University.
A lot of questions you want to ask. My guest is here with me in the studio, Godspower Egbule, constitutional lawyer, political affairs analyst. He has said, well, the reconciliation talks, go ahead to resolve all of these issues. Also trying to make a case with the situation of the Martin Amaewhule and the other lawmakers who had a visit from lawmakers from the National Assembly yesterday that also had put them in the spotlight. Before the break, I was putting out a document, which is more like a press release from the Commissioner for Information. And he was also trying to give legal implication of the whole situation. First of all, put out something he said about the visit yesterday that saw national lawmakers come into the state to see Martin Amaewhule-led assembly. And the Rivers State Commissioner for Information, responding to that visit, said quite a lot. I'll try to get out that statement. I think, let's give me a minute with that, if I can find it. Okay, so the Rivers State government had called on Martin Amaewhule-led assembly to stop misleading the public on their status as members of the House because they had since lost their seats following their alleged defection to the APC. The State Commissioner for Information made the call in a statement. He said that the 22nd January judgment of Justice Omotosho of the Federal High Court in Abuja does not touch nor alter the status of Martin Amaewhule-led assembly as they lost their seats following their voluntary defection on the floor of the House of Assembly in December. He also said the issue of whether the remaining minority lawmakers can carry on with businesses of the House after the majority defected to the APC was not raised nor discussed in that judgment by Omotosho, which is something that we also brought up at the time. The Justice Omotosho judgment did not say you are the rightful lawmaker of the Speaker of the State Assembly, and so on and so forth. Did it?
No, it did.
It stated it?
Yeah.
Do you have a copy of the judgment? Let's look at it.
I will tell you. Let me just read to you
what exactly the judgment says.
Of Honorable Justice Omotosho with respect to the speakership of the Rivers State House of Assembly. Just give me
and their position as members of the House.
Just give me 1 minute. Let me show you.
So while we wait on that, send in your questions and thoughts to WhatsApp 080903064116. I would also be open phone lines. I'm sure a lot of people have plenty to say. There are also lawyers listening who might want to call in and give their own view on this. I was also reading part of some of the statements from the Commissioner for Information, and a part of it says, okay, I told you part of it already. Based on the Justice Omotosho gave his judgment, which completely left out the relevant issues and facts. Since the fact of defection and its legal effects were not raised, nor argued, nor determined in the case, the judgment of Omotosho is legal authority for only the facts in the issue and the issues for determination in that case, none of which touches on nor relates to their defection and its effects, which is automatic and mandatory loss of their seats. So, according to the Constitution, he also said in another material fact issue is Rivers State is whether the remaining minority leaders can carry out. I already told you that, of course, looking at their judgment. Then this is where it was interesting. The Supreme Court of Nigeria case of PN Udo Trading Co. versus Abere 2001, Justice Kabribi White, JSC, stated that although a judgment of a court of law creates law, yet the judgment not being a legislation has no universal effect, but is limited to the parties and the situation in the case, and is not applicable to nor concerned with facts not before the court in the case or to similar facts. Let's get the Omotosho judgment exactly.
You see, one of the orders that Honorable Justice J.K. Omotosho made on the 22nd of January 2024 is that an order is hereby made restraining the 11th defendant. The 11th defendant in this suit is the governor of Rivers State, from howsoever, in whatsoever manner, making any request, presentation, or nomination to the Rivers State House of Assembly, except to the Rivers State House of Assembly under the leadership of the second plaintiff as Speaker. The second plaintiff in this suit is Right Honorable Martin Amaewhule.
Okay, that's the same question we're asking. So did it state that this Martin Amaewhule is the rightful Speaker of the State Assembly? What was the prayers and what exactly was the context of the judgment? I'm saying this because while you were citing the Constitution as it suggests, leaving office, vacate your seat upon defection, you said something very instructive, which was It did not say automatic or did not say this or that or that. This particular judgment too did not specifically point out certain things that Rivers people would want to hear, as against directly stating whether this or that person or this person is in charge of the house. Don't you think that's where now there's the issue?
Hold on. That's an argument that suffers from poverty of logic. I mean, the judgment says, do not make any other presentation. Do not make any requests. Do not make any nomination to the Rivers State House of Assembly other than the House of Assembly led by Right Honorable Martin Samehule. Which other argument do you want to make?
But the argument from the government at the time was that we're still trying to determine whether Martin Samehule and the others are still lawmakers.
Let me even address what the commissioner said with respect to whether Okojumbo can still continue to act as speaker. You realize that at some point, I think that was in May 2024, Honorable Justice Wali gave a restraining order against Martin Samehule and the other members of the Rivers State House of Assembly. That matter went on appeal. The Court of Appeal quashed everything that Okojumbo did, including the screening of commissioners, everything that Okojumbo did. That matter is not at the Supreme Court. So at the moment, there is not even any ground upon which Okojumbo can still continue to sit. There is a subsisting...
That matter was from the High Court here in Rivers State?
Court of Appeal. Yes.
Court of Appeal here in Rivers State?
Yeah. The Court of Appeal quashed everything that Okojumbo did. By virtue of Section 287 of the Constitution, subsection 2, the judgment of the Court of Appeal binds every other person and indeed inferior courts. So on what basis is Okojumbo doing what he's doing? Right. There's a subsisting order, there's a subsisting judgment of the Court of Appeal.
Let's go to
that. Whatever the commissioner is saying, it appears it's not in tune with the several judgments delivered.
All right. In Transamadi, Eli is on the line. Good morning, Eli. Let's hear you.
Yeah, good morning. It's Amy.
All right, good morning.
Good morning, my brother, my friend, Godspower Egbule. Okay, let me lay a foundation here. That by our common practice as lawyers, we are bound to speak the truth that leads to justice as Minister Assembly of Justice. Let me also say that in doing that, no two lawyers may necessarily agree on any issue in contestation. And that is why even at the level of the bench, you find an appeal panel where you have three judges sitting. Three justices of the appeal court sitting. There could be a dissenting judgment, and you go to the Supreme Court, 5 justices. So let me lay the foundation first. Now, with respect to what I've had my friends and brother put up here, I think we're not doing justice to this case. First and foremost, Egbule knows that as of November 29, 2023, Martin Samehule was sitting in the chair of Speaker of House Assembly of Rivers State. No contention. He was Speaker when he filed that suit FAC 1613 before Justice Omotosho for the Federal Court of Abuja. So he also knows that in litigation, the parties that come to court, the way they describe themselves is the way the court delivers the judgment on the facts. He also knows that after December 11, when they defected, several things happened. I'm not talking about automatic votes of seats. It's not cash in the Constitution, we agree, but the Constitution has been interpreted by the Supreme Court to mean that word shall means that you shall automatically vacate your seats. That's what they said they failed that against all the self-assembly. He knows. Now, when the Supreme Court has ruled on an issue of law, the doctrine of silent decisions comes to operate. Every court is bound by that decision, believes that Supreme Court. Even the Supreme Court itself is bound by it. So the question of defection, whether or not it's automatic or not, is not there. Above all, let me emphasize, you hear me? Now, in law, we say the express mention of a thing or in a class of things without another means that you cannot bring it in. Expressio unis exulterius exclusio in Latin. What that means that in section 109 sub 1G, no mention was mentioned of the word court. If you go to 109 sub 2, you see what the law says. The speakers are giving effect, not the courts. In the case of Rivers State, after December 13, Speaker here, sanctioned by High Court of Rivers State, have given effect to that by written INEC. That's where. Now, back to the social issue. Remember that after the president intervenes, All right? In paragraph 3 of that directive, it said those who resign from the PDP, that's another fact. Now, it said they should be allowed to sit anywhere. Now, again, the first directive said the government should withdraw its court processes. Directive 2, that the assembly should withdraw the impeachment proceedings. Now, the government complied with Directive 1 and withdrew before Motor Show. So before Motor Show, there was no position. And second affidavit showing that this was defected. So up to the appeal court, when the governor filed to challenge the decision of Motor Show, the appeal court refused to hear him and said they waived their right to be heard.
All right, Eli, we have to move on now. I think you made your point very clear from a legal perspective.
I almost done, please. I almost done on this point. Please. Now, the Supreme Court itself would have gone the same way if the governor had not withdrawn. But the issue of budget and all that, the Federal Court has ruled, even the Supreme Court has ruled that, look, the Federal Court has no jurisdiction. On December 13, 2024. Now, in law, the last decision of the court is the one that binds. It's citing appeal court judgments that were before now that have nothing to do with this. Appeal court judgments that have to do with judgments of the Federal Court that has to do with 27273. The last and relevant potent decision of our appeal court on the State defection case is the one that happened, Justice Booker, on December 13, 2024. All
right, Mr. Eli, thank you very much, but we have to move on now. To Emeka and Alimini, we also have Chiba and GRA. You would respond to that. Let's just take all of the calls and then we come back to you. Emeka, good morning, quickly.
So I wonder the kind of lawyer we have now in River State, where they are seeing a clear defection. They are coming to mislead the public. Martin Egbule and his cohort truly defected on the floor of the assembly. They sworn an affidavit. And Egbule even read the defection letter, where they went to national chairman of the party. They received them. There was a dinner here, River State, to welcome them. So what is the young man doing there in your studio? Why is he trying to lead River State people? And they also went to Tinubu, that is the president of Nigeria. It's aware, it's our witness that they have truly defected. They should stop dropping River State. They have gone forever. Thank you and God bless you.
All right, Chima and GRA, quickly, good morning.
Good morning, Andrew. Andrew, you asked a question. That is where I'm dwelling on. Should reconciliation be the best option? Andrew, I will say yes. On one condition. Any reconciliation that is detrimental to the common patrimonies of River State do not come at all. Because that is what I see that your lawyer is talking about right there. I tell you. You see, sentiments must not cloud our sense of reasoning when we are, making, analyzing issues. We have nowhere to stand right now. It is so glaring to everybody where your lawyer is standing right now. Now, I listen to legal luminary, Femi Falana. He made a categorical statement regarding this very issue. Now, he said, just like the last caller, that when Martin Egbule approached the court, that Martin Egbule is not telling the court that he had defected. So it was so glaring to everybody. So why would somebody come out because you're a lawyer? You want to deceive people? All these lawyers who live by the defense of politicians, they won't allow us to...
All right, Chima, thank you very much. We don't need you insulting the personality of anybody, all right?
Let me just address...
JJ, just this more, and then you respond to all because we don't want to exhaust the time. JJ in Rumigbo, quickly.
Yes, thank you very much. Let me greet your guest in the studio. My question to him is this. Since you claim that Martin Egbule got judgment from Omotocho's court on false pretense, because at the time they got that judgment, there was no defection. Don't you think that they lost every privilege that the judgment gives them by defecting from one party that sponsored them to another? Don't you think so? And that again, that also made Martin Egbule, if he had stayed back according to analysis of Femi Falana, while others go, he would have remained as the speaker. But the privilege of being speaker was also lost as at the time he also wrote his own letter and now moved to another party. Now, all those claims you're making that appeal court is, what was the subject matter before the High Court and the appeal court that you're claiming judgment for? Is it about defection? If defection matters are not heard, I don't think anything can solve anything right now. I think that's why the Supreme Court is very careful and the Federal High Court, because we all know, within you. If not, we'll go to right and go swear. If you don't know...
All right, JJ.
Thank you very much.
Andrew, let me address...
And then Dakuku. Just Dakuku. You'd address to it. You'd have about 4 minutes to do that, 5 even. Dakuku, quickly, straight to the point.
Okay, so people, I want to ask you
case, he said that Martin Amefe did not defect. Don't you know that they swear affidavit to the court, and if they go to paper publisher and they say they have defected, and everybody was seeing it where they were raising the flag. Don't he see? It's not in the River State for him to say that. Do you know that Martin Amefe and the people have lose that seat? As I'm speaking to you now, forget about what the judge they are talking about the verdict given. The verdict could not favor them not to come back as a member of the House of Assembly. I think he knows that.
All right.
Stop here. Thank you.
Thank you. Now let me start from the last 4 minutes.
Yes, let me start from Sobere Eli. You see, as lawyers, we must not be emotional and sentimental about issues. Sobere Eli has made some arguments that that judgment of Honorable Justice Omotosho was given either way when they were still members of the House of Assembly and now that they have defected. Let me also tell you that at the Court of Appeal, one of the issues that the governor raised was that they have also defected. You see, he who alleges must prove. And when you prove in civil matters, it's on the balance of probabilities. If you're not able to prove your case, you would lose it. You have been arguing that they have defected. Oh, they have defected. You went to the Court of Appeal, you were not able to prove it. You lost at the Court of Appeal, you went to the Supreme Court, and you withdrew your processes. What does it mean? That you're now bound by the judgment.
The processes withdrawn at the Supreme Court had nothing to do with the defection, was it? It was with regards to the 2024 budget.
No.
That was what it was, wasn't it?
The judgment of Omotosho dealt on several abuse. It's indeed. And Sobere Eli, I'm sure he has not read the judgment of Honorable Justice Omotosho, because if he has, he can't still be making recourse to what Edison Ehie did, because Honorable Justice Omotosho set that aside. All the deliberations that Edison Ehie did was set aside. The governor went to Court of Appeal, argued, and one of his arguments was that they have defected. He lost at the Court of Appeal. He filed an appeal to the Supreme Court, exercising his right of appeal. And he went to the Supreme Court and withdrew his processes.
So what matter is to the Supreme Court with regards to defection? Because that is still there.
That's what when you remember that the provisions of the Constitution, you have a right to appeal against a judgment that you have reservations with. You also have a right not to appeal. I just quoted section 287 of the Constitution, which makes judgment of the Supreme Court binding, judgment of the Court of Appeal binding, and judgment of the Federal High Court. You know, there is a misconception that people have that once a State High Court or Federal High Court gives a judgment, you have to wait until the Supreme Court gives that judgment. That is to the point that you appeal it. If you don't appeal against that judgment of the Federal High Court, it's binding on you. So the governor lost at the Federal High Court, went to the Court of Appeal and made an argument that these people have defected. He lost because there was no evidence to back it up. He now went to the Supreme Court and withdrew his processes. Well, when you withdraw your process, when you withdraw your appeal at the Supreme Court, you are bound by the judgment of the Court of Appeal. Because you're telling the Supreme Court outrightly that I do not want to exercise my right of appeal. I now want to be bound by the judgment.
So it brings us to this question. Are you saying that there are no other cases in court filed by the state government questioning the defection of Martin Amefe and others?
That's the one that came up yesterday. And
what happened with that?
The courts had to adjourn to say, let us wait. Hold on. Let us wait. With the greatest respect to him, I have the greatest deference to Femi Falana SAN. But you see, on the Rivers issue, he has been emotional and sentimental. He was one who told the public that they are going to Federal High Court because there is nothing the Supreme Court will do. They went back to Federal High Court. Federal High Court referred them back to the Supreme Court. You see, you have a right to a legal practitioner of your choice, but you will bear the consequences of any judgment that the court gives.
All right.
Irrespective of any propaganda that you put out.
All right, Mr. Godspower, thank you very much. We wrap it up here.
Mom's love is pure.